Hey everybody, I'm here with a quick video on Diddy's defense team. Listen, the prosecution, they submitted a letter to the judge saying they think that Diddy should at least get 11 years behind bars. Well, the defense team responded and pretty much they're telling them like y'all got to knock this off. Y'all got to stop disrespecting a jury's verdict and also trying to do double jeopardy. And I agree. The jury has spoken. Y'all need to respect it. Now, if it was the opposite, if the jury would have came back and said that Diddy was guilty on all charges and he would have started trying to backtrack and say, don't listen to this, don't listen to that, the jury got it wrong, they would be saying that this man is so disrespectful and he's disrespecting the jury, but they're doing it and they thinking nothing of it. Let me share a screen. So let's see if I can give you read off this response to you. It is on the Shade Room's page. I'm going to try to read it because it's so tiny because I couldn't bring it up anywhere myself. But let's see if we can decipher this and get through this. It says, as we have emphasized many times, the jury has spoken. The government presented its best evidence to 12 citizens to try to prove Sean Combs used threats, force, fraud, and coercion to compel his girlfriends to engage in freak-offs and hotel nights, and it failed. Mr. Combs now stands before the court to be sentenced for much less serious offenses. If fairness, justice, and the U.S. Constitution mean anything, the jury's verdict should be respected. Mr. Combs should be sentenced for what he is convicted of: transporting consenting adults interstate to have sex and nothing more. Instead of accepting the verdict and advocating a reasonable sentence, the government has gone to extreme lengths to try to justify a draconian sentence, particularly for a 55-year-old man. Instead of addressing the context for which Mr. Combs was convicted, the government has devoted 161 pages to rehashing evidence rejected by the jury and concocting far-fetched legal arguments to try to jack up the guidance ranges to an absurd 360 life level, as if he had been convicted not only of the acquitted charges, but also other charges, other uncharged offenses. It labels as victims numerous individuals who had nothing to do with the Mann Act charges, dredging up discredited witnesses like the woman who calls herself Mia, Deontay Nash, Brianna, and even Jordan, that's the chef, a person whose allegations are so incredible, the government pulled her from its witness list mid-trial. And instead of putting forth a reasonable guidelines range for addressing where the case fits within the relevant sentencing data, the court directed the parties to provide. The government asked the court to treat it like a sexual assault or case, and that was not and could not have been charged. It is not difficult to see what's going on here. The prosecutors know full well the court will not actually adopt all of their unduly severe enhancements or baseless arguments, but by taking their advocacy to the extreme, they hope to persuade the court to disregard Mr. Combs' position, split the baby, and adopt probation's recommendation. That would be a grave mistake. Probation made clear its recommendation is based on the premise that there was force, fraud, and coercion here. Its recommendation is improperly based, in other words, in acquitted conduct. In light of the jury's acquittals, the long-standing Department of Justice policies, and all the relevant sentencing data, any sentence exceeding a modest term along the lines requested by Mr. Combs would be unreasonable and disproportionate to other Mann Act cases. The government's advocacy in this case has gone way beyond zealous. It is indecent and deeply troubling. It violates the reverend principles so famously articulated by Attorney General Robert Jackson over 85 years ago about the proper role of the federal prosecutor. He observed that because the prosecutor has more control over life, liberty, and reputation than any other person in America, These awesome powers must be tempered by the spirit of fair play and decency that should animate the federal prosecutor. As he explained, while you are being diligent, strict, and vigorous in law enforcement, you can also afford to be just. Although the government technically loses its case, it has really won if justice has been done. Moreover, a sensitiveness to fair play and sportsmanship, and perhaps the best production against the abuse of power and the citizen's safety, lies in the prosecutor who tempers zeal with human kindness and who seeks truth and not victims, who serves the law and not fictional purposes, and who approaches his task with humility. The prosecutors have not lived up to these principles and apparently do not respect the unanimous verdict 12 New Yorkers rendered in the case. But fortunately, the fate of Sean Combs is now in the court hands. Like all human beings, Mr. Combs is flawed, but he is the first to admit he has made many serious mistakes and has been working very hard to better himself and make the most of his time behind bars. We respectfully submit that he deserves a chance to continue his rehabilitation outside the walls of a prison and ask the court to be merciful and afford him that opportunity. Mr. Combs has already spilled much ink and submitted voluminous materials that we hope will assist the court in fashioning a just sentence. We submit this reply brief solely to respond specific arguments in the government's brief as to the proper role of acquired conduct at seeking sentencing. Certain guideline issues, the government sentence disparages arguments, and factual issues related to Mr. Combs' treatment and time at the MDC. The government's Dragarian guidelines, calculations, defines the laws and the factual record. The government seeks a severe sentence based on the same arguments that filed to persuade the jury about threats, force, fraud, fraud, or coercion. Hypothetical distinctions aside, the government argument boils down to a clear that this is not just a Mann Act case, because Cassandra Victoria and Jane did not voluntarily travel to freak-offs and hotel nights. But regardless of the precise words used, force, fraud, coercion, threat, manipulation, the government arguments for a Draconian sentence for these transportation offenses are materially indistinguishable from the arguments that failed to persuade the jury Mr. Combs was guilty of sex trafficking. At trial, court instructed the jury that it had to find that force, threats of force, fraud or coercion, or any combination of such means would be used to cause the alleged victim to engage in commercial sex act in order to convict Mr. Combs of sex trafficking. In defining these terms, the court instructed that coercion includes threats of serious harm, including both physical and non-physical types of harm, such as psychological, financial, or reputational harm. It also instructed that such threats must be sufficient in kind or degree to overcome the will of ordinary person having the same general station in life that of the alleged victim, causing a reasonable belief that there was no reasonable choice to accept, engage in a commercial sex act as directed by the defendant. Coercion could also be proved, if the court instructed, if the defendant engaged in a scheme, plan, or pattern intended to cause the alleged victim to believe that if he or she did not engage in commercial sex, he or she would suffer serious harm. The government repeatedly told the jury the evidence showed just that. To take just a few examples, the sex trafficking charges in the case are based on the defendant's legal actions over the course of his relationship with Cassie and Jane. There is drugs, lies, manipulation, and violation. The legal actions that caused Cassie and Jane to have sex with paid escorts in front of the defendant. The legal actions that made Cassie and Jane believed that they had no choice but to do the freak-offs and the hotel nights even when they didn't want to. So they're giving here all the different situations in which was before the jury, and the jury said not guilty. So they're saying, like, how do you now come back and you want to keep drudging up this same stuff that he was not found guilty of for the judge to consider his sentence? That is double jeopardy. That can't happen. You can't retrial the case just because you don't like the man. You don't like the man. You're disrespecting what the jury, the verdict they came up with. You saying they got it twisted, and you want the judge to make things right. It's disrespectful. You can't do it. It's not constitutional. So y'all can hate me, Diva, for giving y'all the words, but here it is. His defense attorneys are letting the prosecution know y'all was running a circus the whole time. And now y'all really crossed the line. Even though y'all ran a circus, we beat y'all at your own game. Y'all was playing checkers, we played chess. Now you're pissed. You want to blame everybody but yourself. You don't want to say, I could have did better. And they also got mad because at the end of the day, the prosecutors got pumped by the defense team. They brought not one witness. They didn't, after the prosecution did their whole case, that tells you was an epic fail, right? They did their whole case. The defense said, we don't need nobody because y'all ain't bring nothing here. There's nothing to see here, people. We're done. We're good. They took that chance, put no one on the stand, and they still got a not guilty on the more serious charges. Then I'm sorry, prosecutors, y'all got to take the F. But instead of taking it, you're going to have this rehash and all these letters that saying the same thing. Y'all got to come one better. Listen, guys, chat with me in the comments, and when I get opportunity, I will chat back. If you're not a subscriber, subscribe. Hit the notification bell so that every time I upload a video, you will be notified. If you are a subscriber, welcome back. Everybody, thanks for watching. Let me know your thoughts on the defense coming back, telling the prosecutors, y'all need to stop it with this 11-year recommendation of a sentence. See, they tried to get Diddy to do a plea deal before this even went to court, and they wanted him to do 20 years. He said no. So y'all coming back after he was found not guilty on the more serious charges. Y'all wanted him to do 20 years on all the charges. Now y'all coming back and say he need to do 11 years for just the Mann Act. They got to stop it. Hit the like button. Chat with me. Let me know your thoughts. I'll see you on the next video.